All right, time for Ask Vinny. You've been sending us all your questions on social media, also taking your phone calls, 877-JUROR-13. Let me introduce my guest who will be answering your questions. In session field producer Michael Christian. There he is. Great to see you, Michael. He was in the courtroom for all of this trial. Criminal defense attorney Louis Gainor joins us. Great to see you. And in session law enforcement analyst and contributor Mike Brooks with me here in studio. Let's get to the questions. First one comes from the Facebook. Okay, Chris, none of these cases end up in a plea. All right, Joni on Facebook has a question here. Louis, I'll throw this one to you. I would like to know if an appeal is applicable due to the major mistakes made by the defense attorney. How about that, Louis? What do you think? Let's talk in general first, and then if you have any specifics about this case, you can go into it.
All right. Well, let me throw the question right back to you. Is what major mistakes were there? What defense was there available? It didn't seem to me like there was a defense. The evidence seemed overwhelming. It's always easy to blame the attorney. At the end of the day, we have to work with what we're given. In order to appeal a case based on the mistakes of the attorney, you have to allege ineffective assistance of counsel. And there are two parts to that. Part number one is you have to show that the attorney was negligent in some way. And part number two, and this is critical, you have to show that the negligence actually made a difference in the verdict. Because any guilty person could say, well, my lawyer didn't do a good job. But you have to show that it actually made a difference. If the evidence is overwhelming, then it doesn't matter if the attorney committed some mistakes. And there's one important rule from the appellate courts, and it's that the appellate judges are always going to respect the attorney's trial strategy. Because in cases like these, you have to get creative. You have to find ways to win. And so an attorney might have to take a risk, and sometimes that can backfire. But the appellate courts will say, we're going to give you some latitude here because we understand that there's just decisions you have to make in the heat of the moment. And you might want to look in hindsight and say that you would do them over better again, but we're still going to respect the decisions you made on the day of trial. So
yeah, just because you get yelled at by the judge, that's not a reason for an appeal here. But you make some great points. Louis, I got one for you. This is from Mara on Facebook. Do you think Holtzman's kids should testify against her no matter their age? They are the biggest witnesses. I can only imagine one of her daughters saying, well, Mom walked into the bathroom and walked back out a few minutes later with no eyebrows.
Well, the question implies that it would be the defense attorney who's calling the children as witnesses to prove that she was insane. The first rule is this. Kids cannot testify unless they are competent witnesses. That means they have to be old enough to be able to distinguish between what is true and what is a lie. And so if they're too young, they're not going to take the stand. There's no point. As a trial strategy matter, calling children can be very risky because it could alienate the jury. They could say, how dare you put that kid through this just to benefit your guilty client? But it can have a big reward as well. You know, where there's risk, there's reward. You put children on the stand, what's the prosecutor going to look like trying to cross-examine them? How much of a jerk would the prosecutor seem like if he drives one of the defendant's children to tears? So the children would be relevant to establish the insanity defense, but the prosecutor, on the other hand, could use them to say, look, from the beginning, the whole family knew that your mother wasn't sick. This was all her scheme to get that money.
You know, Michael.
And law enforcement, that is who specifically is mentioned. And they specifically say that they are not intending to gag the defendant or family, friends, etc. Okay, so Louis Gainor, let's talk about the other side of this, right? You've got Trayvon Martin's attorneys, Trayvon Martin's parents. They have been very, very vocal here. If prosecutors can't speak, they may end up being the voice of that side of this story, that side of this case.
Well, my question is, why are we talking about a gag order before the trial has started? Because everybody knows that George Zimmerman has been tried and convicted in the court of public opinion. The prosecutor has come out from the beginning in a media campaign, a witch hunt against George Zimmerman. And the defense has had no opportunity to respond to that. The prosecution comes in with the authority of an elected office, with all the advantages built in, and from the beginning did nothing except respond to the media frenzy that this case created. And so my question is, why are we saying it's unfair for the defense attorneys to want to speak up and actually defend their client? At the end of the day, can you really promise him a fair trial given everything that's happened? Does he even stand a chance in front of 12 people down in Florida? That's what this issue is about. And And so at this point, the judge needs to issue an order which gives fairness on both sides and respects the First Amendment. Because I'll tell you this, and then I'm done. It's going to be a dark day in America when you can't express yourself under the First Amendment when you're charged with a crime.
You know what? I agree in part and disagree in part with, and I also disagree with Louis Gainor. He's going to get a fair trial. We're going to get a jury. We're going to get a jury. Everyone gets a jury. Everyone gets a fair trial. Ask O.J. Simpson. Ask Casey Anthony. Any of them. You get a fair jury. Let's listen to this, though. I want you to take a listen to George Zimmerman himself because he has also spoken out. George Zimmerman. And I think he's almost his own worst enemy when he talks. Here he is on Fox News' Hannity.
To get it back on an even keel. And I think he did that.
Louis Gainor, what in the best case scenario, how should a case proceed? Everyone can talk and say whatever they want about anything, or no one should talk, or is it something in between?
Well, I'm going to give a one-sided answer, and it's not because I'm a defense attorney, I swear. It's that the prosecutor has to abide by more rules than the defendant. And this is the reason why. Because the prosecutor can put people in prison. They can execute people. They have inherently more power, more authority than the other side in the case. So we have to have them abide by certain rules that don't apply to the defendant. For example, prosecutors who make inflammatory comments to the press about a defendant. The defendant is the one that has the right to a fair trial. Now, I'll give you this. The prosecutor is entitled to a fair trial as well. But think about it. The Founding Fathers wrote those amendments to our Constitution, and does a single one of them say the prosecution has a right to a fair trial? It's the defendant. The entire Bill of Rights is written for the defendant. So the rules have to be crafted in a way that keeps the defendant's right to a fair trial alive. But also, you know, it's got to hem in what the prosecutor says to an extent. It's got to be, to an extent, tilted towards the defendant's favor.
And, you know, in my experience here on In Session, covering cases all over the country, I found that it's a little bit easier usually to approach and get conversations with defense attorneys than prosecutors, just because of what Louis Gainor was talking about there. Prosecutors have a different obligation, and I actually agree.